I think first of all I want to just give a brief description of the court and the difference with other courts, because I see that there is a lot of confusion. The International Criminal Court was established in 2002, July of 2002. And it is the first permanent international criminal court to be established. It is established by treaty, the Rome Statute, which was signed in 1998 in Rome, requiring ratification to come into existence. And I can say that between 1998 and 2002, when the court became established, it is one of the fastest treaties to be established. In 4 years, we got the number of ratifications needed for the court to be established in 2002. And today, 122 states are part of the ICC. They have signed and ratified the Rome Statute, which is the founding treaty of the ICC, and they are part of the International Criminal Court. It is different from the courts that existed before. Example, the ICTY, which is the International Criminal Tribunal for the former Yugoslavia. This was a court that was established by the United Nations, acting under Chapter 7. They established the ICTY in response to the conflict in the former Yugoslavia. So it is limited to that. There was also the ICTR, which is the International Criminal Tribunal for Rwanda. And this was also established under the same, by the same United Nations, but also in response to the Rwanda genocide. So this is all these courts, of course, are ad hoc tribunals based, limited in geographical scope. But the ICC is different in the sense that it is not a United Nations creation. It was not created by the United Nations. It is not a body or an agent of the United Nations. It is created by states who have signed and ratified the Rome Statute and are part of the International Criminal Court. The jurisdiction of the court, however, is similar to that of the ad hoc tribunals that I have mentioned. Our jurisdiction is over war crimes, crimes against humanity, and genocide. And potentially, maybe against, we will have jurisdiction in the not too distant future on the crime of aggression. But that has not happened yet. But now we are dealing with these three crimes: war crimes, crimes against humanity, and genocide. I think it is also important to explain how the ICC can intervene, can exercise its jurisdiction over these crimes that I have mentioned. The ICC's jurisdiction is triggered if any state party that is part of the ICC requests the ICC, we call it a referral, requests the ICC to intervene or to exercise jurisdiction on its territory where these crimes have taken place, and that particular state is not able to do it themselves. So they can refer the situation to the ICC. And I'll give you an example. So far, we have Uganda referring a situation to the ICC. We have the Democratic Republic of Congo. We have Central African Republic. We have Cote d'Ivoire. And recently, we have Mali. And a second time, Central African Republic. They all requested the ICC's intervention because they are states parties, and they are not, they have made declaration, or they have shown that they are not in a position to exercise jurisdiction over these very serious crimes. This is one way in which ICC can exercise jurisdiction. A second one is when the United Nations Security Council, acting under Chapter 7, decides to refer the situation to the ICC. So in that case, where the conflict is taking place, that state does not have to be a state party to the Rome Statute, because in this case it's the United Nations that is referring. And the two examples that we have so far is the case of Sudan, Darfur. It was a referral from the UN Security Council, and Libya. Libya was also referred to the ICC by the UN Security Council. And of course you will note that neither Libya nor Sudan is a state party to the Rome Statute. But in this particular case, as I said, it is the UN Security Council, being responsible for world security and peace, and acting under Chapter 7 of the UN Charter, decided to refer the situation to the ICC. In fact, under the Rome Statute, the UN Security Council is mandated to be able to make these referrals to the ICC. That is the second way. The third way is when a state that is not also part of the ICC decides to make a declaration accepting ICC jurisdiction. We call this the Article 12.3 declaration. Even though it has not signed, not ratified the Rome Statute especially, it can actually make a declaration and say, I accept ICC jurisdiction, and invite the prosecutor of the ICC to exercise jurisdiction there. And so far we have also had, we also have an example. For instance, Cote d'Ivoire, before it became a state party, the first time we were able to exercise jurisdiction was as a result of a declaration that was made by Cote d'Ivoire as a state, inviting ICC to intervene. And finally, the prosecutor of the ICC, under the Rome Statute, has a mandate to intervene in a situation or to exercise jurisdiction in a situation where these crimes that I have mentioned are happening on the territory of a state party, and that state party is not doing anything to address it, or maybe is not genuinely addressing it. And we have an example again where the proprietor powers of the prosecutor, we call it, was used in the case of Kenya. After the post-election violence of 2007-2008, and these alleged crimes were said to have taken place, and Kenya failing to exercise its jurisdiction over these crimes by either establishing a tribunal or trying the perpetrators of this crime, the prosecutor of the ICC, seeing that there was this failure, and of course there was this fact that these crimes needed to be addressed, my predecessor used his proprietor powers to intervene in Kenya to exercise jurisdiction over these crimes. I think the language of this statute was very carefully worded. It is when the state is unwilling or unable. When you talk about unwilling, maybe it is political will, and perhaps maybe the person who's involved. There is no political will to be able to exercise jurisdiction over that person or those persons who have committed these crimes, or unable. And here we talk about lack of capacity. And we have seen this happen. In several conflicts, you find that the infrastructure and everything is so destroyed. The system is so destroyed or so damaged that you do not have people who are readily available to be able to, yes, to be able to address the crime, because the capacity is not there. And I think in most of the interventions that we have had, even though there are situations where there is lack of political will, but the majority of them is also capacity. I recall when the first referral we received from the Central African Republic asking for the ICC's intervention, it was even followed by a declaration saying that they do not have the capacity to be able to investigate this kind of crimes. Because these are massive crimes, very serious crimes, very complicated, war crimes, crimes against humanity, and genocide. You ought to have the capacity to be able to investigate them effectively. I think it is important to hear mention a very important principle in the ICC system, the International Criminal Court system, and that is the principle of complementarity. The ICC is not a court of first instance. It does not replace national jurisdictions. It only complements national jurisdictions. And what does this mean? Is that always in the ICC system, the domestic jurisdiction has the primary responsibility to investigate and prosecute. And it is only when it fails, as I said, whether it is unable or unwilling, that the ICC comes in. Or when they are probably attempting to investigate, but they are not doing so genuinely, that the ICC comes in. So it's a complementarity system that has been put in place. And the ICC does not immediately get into a domestic situation to exercise jurisdiction. We have to do a preliminary examination in which we assess First, whether the crimes have been committed, whether those are crimes that are within the competence of the ICC, whether it is the temporal scope is satisfied, meaning the crimes took place after 2002 when the court became established, and also whether the national domestic jurisdiction is addressing or not addressing. We do this examination first before we move to the next stage of deciding as a prosecutor whether to open investigations or not to open investigations. Actually, to tell you just a summary of the cases that we have right now, we have 8 situations that we are dealing with involving over 20 individuals currently. We have had so far completed two cases. The others are ongoing. The 2 cases, there has been convictions, and this is in the case of Thomas Lubanga Dilo of the Democratic Republic of Congo and Germain Katanga. We have also had one acquittal in the same case, because it's probably good to mention that Germain Katanga was charged with Matthew Ngujolo. And this is all within the context of the Democratic Republic of Congo investigations. And the judges decided to convict Katanga, but Ngujolo was acquitted. It is a situation that, of course, my office has immediately appealed, and it is now in the appeal process. But with respect to the Lubanga, when he was convicted, they appealed, the defense appealed, but we also appealed, and we are waiting for the decision, which they have informed us will be on Monday, which will be the final decision. We have also completed the case of Jean-Pierre Bemba Gombo. Jean-Pierre Bemba is a former vice president of the Democratic Republic of Congo. His case is now completed. We've done the closing arguments, and we're waiting for the judges to give us the decision on that case. We have handled the Darfur situation, in which already I think we have issued about 5 arrest warrants against President Omar al-Bashir, Khushaib, against also the other side, which was against Banda, Jerbo, and Abu Garda. Abu Garda, during the confirmation hearing, the judges have decided to not confirm the charges, but the case of Banda and Jerbo unfortunately has died, and Banda is supposed to, this trial is supposed to start if he does come to the court. It's something that we are dealing with. So there are several cases. There's the Libya cases, in which we had charged 3 individuals, the late Muhammad Gaddafi, the son, Saif al-Islam Gaddafi, and Abdallah al-Sanusi, in the Libya case. In Cote d'Ivoire, we have also charged President Laurent Gbagbo, the former president of Cote d'Ivoire. We have charged Charles Blé Goudé, and also Simone Gbagbo, the wife of Laurent Gbagbo. So it's several cases. Maybe I should mention that recently we have had to charge people not with our core crimes of war crimes, crimes against humanity and genocide, but with crimes against the administration of justice. Because what we have noticed is that we see across our cases that people are trying to interfere with our witnesses by either intimidating them, bribing them, coaching them, or even killing them. And it was a responsibility that I undertook to show that you cannot be interfering with the witnesses of the ICC for such serious offenses and then nothing happens. So I was able, in the case of Jean-Pierre Bemba, I was able to get 5 individuals charged of these crimes and brought before the ICC. And just recently, judges have agreed and confirmed the charges against them, including the lawyers, the lawyers of Jean-Pierre Bemba and the case manager. Also, in the Kenya case, I have had to bring a case against one national of Kenya called Walter Barasa for the interference with witnesses. He is yet to be surrendered by the Kenyan government to the ICC, but I think this is the message that we have to send, that these are very serious offenses. The witnesses are taking very serious risks to come to the court to give evidence in these situations. And it is the duty of the court, my duty as a prosecutor, but also the court, the judges, to ensure that these witnesses are fully protected and that they are not subject to interference in these situations such that they are probably not able to come forward to give their evidence, but also, in the end, derailing the cases themselves. So this is very serious, and I have also had to invest resources to investigate this kind of crimes. The ICC will never refuse any demand, just like that. What we don't do, or what we have to ensure, is that our jurisdiction is met. This is very important. And that is why I took time at the beginning of this interview to explain how we can intervene and how we cannot intervene, why we intervene here and why we don't intervene here. Because one has to understand that it is all a matter of jurisdictional function. If we have jurisdiction, where, for example, it's a state referral, or it is a UN Security Council referral, or it is a proprio motu by the prosecutor, or it's a declaration. In all of those instances, we have to check whether our crimes have been committed. We have to check the temporal scope. We also even have to check whether it will not be against the interest of justice for ICC to intervene. We look at all those cases. Sometimes we may not want to exercise our jurisdiction because of the gravity threshold, in the sense that the case is not grave enough to warrant the intervention of the ICC. And when I say grave enough, I'm not just saying that if a few people are killed, it's not grave. No. The gravity threshold looks at several things. It's the nature of this crime, the scale of the crimes, the impact that the crimes have on the region or in the country, and several other aspects. We look for it before we say that this is a case that is so grave that the ICC has to intervene. But in some instances, we may not intervene because of the gravity threshold. I'll give you the recent example of Comoros, the Union of Comoros. The Union of Comoros had made a referral to the ICC over the incident on the Mavi Marmara flotilla vessel, in which people were killed by the Israeli Defense Forces. I have come out to say, after a thorough analysis, with careful consultations, we looked at both the legal and the factual basis very carefully. And my office has come out to say that yes, war crimes have been committed on that boat, but the crimes themselves are not of sufficient gravity to warrant the intervention of the ICC. And in this case, one does not, we were just looking at that incident isolated in the boat itself. We are not looking at the overall conflict that everybody is talking about. It was just that incident that was referred to us. And it was referred to us by the Union of Comoros because that boat, the Mavi Marmara, was registered in Comoros. So it's like happening on the territory of a state party, which means the ICC, they can refer the situation to the ICC. But as I said, having looked at it very carefully, we have come out to say that even though some of these crimes have taken place, it is not of sufficient gravity to warrant the intervention of the ICC. I think the war crimes itself is pretty much governed by all these conventions, the Geneva Conventions. And I believe that it is pretty much customary international law. And the Geneva Conventions, as you have seen, is almost universally ratified. So I don't think we have a problem with definition of war crimes and be able to identify when these crimes occur. I think the problem that we are confronted with is that the scale, and the frequency in which these crimes are happening everywhere. This is the problem that we're faced with, and how the international community can or should deal with it. Of course, we have had demands. We have had, or maybe I can even say, criticisms that why is the ICC not intervening in Syria. And this is, again, I come back to explain that it is just a matter of jurisdictional function. Syria is not a state party to the Rome Statute. It hasn't signed, it hasn't ratified the Rome Statute. Therefore, the ICC could only probably have jurisdiction in two ways. If the UN Security Council were to refer the case of Syria to the ICC, or if Syria were to make a declaration accepting ICC jurisdiction. And as you know, none of these situations has happened. So the ICC cannot, at the moment, intervene in Syria. One aspect, however, that we are monitoring very closely is the issue of all these foreign fighters that are taking part in the conflict in Syria. We are monitoring it closely because some of the foreign fighters are coming from states parties, are nationals of states parties. And ICC's jurisdiction does not only cover the territory of a state party, it also covers nationals of states party. This is what we call the personal jurisdiction. So we are looking at it very carefully, we are looking at it closely to see. I'm not saying that ICC is going to intervene and go after the nationals or not, but we are monitoring it very closely. We are collecting information just to know what this phenomenon is. Even recently, I received the Foreign Minister of Lebanon, who came to the office to raise this issue of foreign nationals, members, part of the ICC states parties who are involved in this situation. So we are looking at that very, very closely, and we are looking at the information we receive. Well, even without a referral, as prosecutor of the ICC, there is the possibility to look at those foreign nationals who are involved in the process. But as I said, it's just at the very preliminary monitoring stage of looking at what really is going on, what is this new phenomenon, because it will be what we will call the personal jurisdiction, the exercise of the personal jurisdiction, and which we've never done before, but of course, which is something that is within the mandate of the court and within the mandate of the Office of the Prosecutor. And we have had information of nationals, as I said, from Jordania, from Tunisia, from all these are states parties, from the Western European countries, who are states parties to the ICC. So we have to make a very careful observation of what is going on.